my colleagues are looking at their bundles, they won't find it. I've just provided the extracts. It's on a separate page. Have you found it? You will see that the ex-Minister of Finance, Mr. Nene, also touched on the things that you have now testified upon. At paragraph 102, he stated the following: SAA was brought under the administration of Treasury on the 11th December 2014, gazetted on the 19th December 2014, due to poor governance and financial instability. At the time of the transfer, SAA's financial position was extremely weak. In the 2012-2013 financial year, the airline suffered a loss of 1.2 billion. The loss increased on 2.6 billion in 2013-2014, and the airline was on track to realize an even larger loss for the 2014-2015 financial year, which eventually amounted to 5.6 billion. The company was technically insolvent, with its liabilities exceeding its assets by 3.5 billion as at March 2014, and was experiencing severe liquidity challenges. It was only able to raise funding with support of government guarantees, and that's what you have also touched on, that during your time, this was your experience of Treasury having to provide those guarantees.
Correct.
Yes.
Mr. Mokoena,
Mr. Chair.
The handwritten notes on those 2 pages, are they Mr. Nene's corrections, or are they your?
No. Those are just for ease of reference, so that you must know where are we finding those documents, where those documents are sourced.
Okay,
Mr. Chair.
all right.
They have nothing to do with Mr. Nene.
Thank you.
Now, in relation to the SOEs, Ms. Hogan, what is the purpose of a shareholders' compact?
So one has to ask the question. The minister is a shareholder for these large enterprises. The minister belongs to the Department of Public Enterprises, which is not a policy department. So, for example, the Department of Energy formulates policy around energy, and there's a document which is produced on a regular basis which looks at the long-term energy needs of the country, and that provides the basis for Eskom to move forward. And of course, there's a lot of consultation with Eskom. So what a minister does in public enterprises is the minister signs a shareholders' compact with the board, in which that shareholders' compact reflects the main direction and the performance objectives that government expects of that company. And it goes through a lot of discussion and whatever, and that is what you hold as a minister, that company to account. So you hold the board to account on that. So that becomes then the mechanism whereby the shareholder has an influence on the direction of a company, its strategic possibilities and whatever, but does not dictate. And it provides a basis for evaluation. In the Department of Public Enterprises, we had what we called a dashboard. So every 3 months, we would look at the results of all the companies. We'd spend a day analyzing those results and then engaging with the various companies on the basis of our assessment.
Yes. Now, who appoints the boards of the SOEs, and what is the role of the Minister of Enterprises, if any, on such appointments?
Who issues?
Who appoints the boards of the SOEs?
Okay.
And also, please deal with the role of the Minister of Public Enterprise, if any, on such appointments.
Okay, it's the minister who appoints the boards of the SOEs.
Yes. Now, can we take through, is there a process that is in place? What process must be undertaken?
Yes. In the Department of Public Enterprises, there are various teams of speciality. You've got to have a team that specializes in energy, in logistics, rail infrastructure, in forestry, in nuclear. It's a wide range that covers a lot of what the economy is composed of. And that team keeps very close to the companies that fall within its speciality. It's a number of deputy DGs, and the DG, the Director General of the department, runs all of that. They have to keep a watch on the board, because the boards are usually appointed for 3 years. And there's the usual provisions that might be in a memorandum of incorporation, which says, a third of the board must move, 2/3. It differs from company to company. But nevertheless, there has to be a succession plan worked out around the boards, and the department has to keep ahead of that. So if it's expected that certain directors will move on, then the search begins. My experience in the Department of Public Enterprises was that the DG would lead the process, but in close consultation with myself. In virtually all cases, a professional search company would undertake professional searches under the guidance of public enterprises about the kind of skills that would be required on the board. An assessment would be made of the kind of skills, what skills were lacking, what they needed more, etc., and that would be in discussion with the present board. And then on that basis, the brief would be given to a professional company. But people would also headhunt. They would also look around and see, and they would also, the board often had a very good idea of who could come in, but that would all be subjected to interviews with the prospective board members, not by myself, but by the professional agencies. There would be competency checks. For instance, in Transnet and the big senior organizations, there would be professional psychological tests done, management competency tests done, and these aren't just, these are used in the corporate world extensively. You really got to have the best of the best on these boards.
Yes, and
Yeah.
And who appoints the CEOs in the process?
The CEO appointment, once again, depends on the memorandum of incorporation or the founding legislation of a particular SOE. I took the view, and that is also endorsed by the opinions of Michael Katz, senior counsel, that appointment, even though a minister may, and it wasn't always, be said to do the appointment, the minister would authorize the board to do a search along commonly agreed parameters. So the minister would never appoint a CEO out of the blue, and would allow the board to go ahead. The reason being is that the CEO is accountable, like I've said. And you can't have a CEO who the board doesn't even know coming in.
Yes. And what is the role of the president, if any, in the appointment of the boards of the SOEs or the CEO? What role does he play?
The President has, in terms of the Constitution, exercises authority in two ways. One, as head of state, and he is permitted in terms of that Constitution to exercise that without consultation with the cabinet, can do, and the President can then do appointments, you know. I'm not au fait with this, but it might be the National Prosecuting Authority, for instance. But the President is also head of the Executive Council, the Cabinet, and exercises an authority there. But in that case, the Constitution lays out what the President's responsibilities. Could I just read that? It's just a very short thing from the Constitution, which spells out the President's responsibilities.
Yes, you may.
Section 85(2) of the Constitution says that the President, in his capacity as head of the National Executive, exercises that executive authority together with members of his cabinet, and does so jointly by, and this is a quote, implementing national legislation, developing and implementing national policies, coordinating the functions of state departments and administration, so it's coordination, implementation, preparing and initiating legislation, and performing any other executive function provided for in the Constitution or the national legislation. There isn't a specific role in any legislation which envisages that the President must make the decision about the appointment of people to a board of a state-owned enterprise. Now, when one becomes a minister chair, you are allocated as a minister an executive authority. As Minister of Public Enterprise, I was given the executive authority to appoint members to the board.
Yes.
I had occasion to seek an opinion from Advocate Wim Trengrove on this matter, because I clearly wanted to understand what my authority was. Firstly, must the Cabinet agree with my proposed candidate? And what role, if any, does anyone else play in this process? If you don't mind, Advocate McQuenna,
yes.
Can I refer to the Trengrove
opinion?
The prerogative of an executive authority?
Yes.
I won't be long. Okay.
Yes, you may.
Now,
I intended to take you there, but now that you are there, it's fine. You might.
is that okay?
Yes.
Okay. The implications of a constitutional scheme, this is what Advocate Trengrove writes
And you are
on
reading
page
from
86.
Page 86, yes.
Paragraph 8. Okay.
Yes.
It is the prerogative, and this is as the minister exercising powers as a shareholder. Firstly, Trengrove says it is the prerogative of Cabinet, in terms of Section 85(2)(b) of the Constitution, to develop national policy. Cabinet may, in the exercise of this power, develop a policy on SOEs. It may determine not only whether there should be such a policy, but also what it is and to what level of detail it goes to. So that's, as I've said to you, I follow the policy departments. The only limitation on this Cabinet prerogative is that the policy must be consistent and may not contradict national legislation. So Trentgrove is saying Parliament, in the enactment of legislation, still means that Parliament determines the full, legislation trumps all. Goes on to say, it is in the first place for the minister to determine how to exercise the state's power as a shareholder. So the minister has the policy, now how do you exercise it? If Cabinet has, however, formulated a policy, then the minister is bound to exercise it in terms of that policy. The minister may consult the Cabinet on the exercise of her powers, but she's not obliged to do so. Whether she does so is in the first place a matter of Cabinet protocol and custom, but not law. And in the second place, a matter of personal discretion. Now, this is an important point. The minister is bound in law to exercise her powers in accordance with these rules. So I must exercise my powers in accordance. It does not follow, however, that if I fail to do so, that the exercise of a minister's powers is invalid. Trentgrove goes on to say, I'm of the view that the minister's exercise of her powers remain valid in law, even if she fails to adhere to national policy determined by Cabinet. So the law trumps all. The external validity of the minister's conduct does not depend on her compliance with the internal policy laid down by Cabinet. The remedy for any failure by the minister to adhere to Cabinet policy is for the President to dismiss her from Cabinet or to transfer her powers to another member of the Cabinet.
Yes.
So my understanding is just clear. Once you become a minister, you are assigned executive powers, and you must exercise those powers in terms of legislation and in terms of the policy given by Cabinet. And as long as you are exercising your powers in that way, you are doing your job.
Yes, now flowing from that testimony and with reference to the opinion that you've read, can the President, acting outside the Cabinet, instruct you as the minister as to which board member you must appoint?
No.
Can a President instruct you as the minister or instruct the board as to which CEO must be appointed?
No.
Now,
that would be in terms of the opinions that are sought. If any Cabinet minister or the President tried to instruct me on who should be appointed, they would be usurping my executive authority. The opinion went so far as to say that if a President or Cabinet minister requested 3 names from which Cabinet would choose, that would itself be usurping the authority, or usurping the executive authority of that minister, because then it is Cabinet that is choosing and not the minister. Now, I don't want a false impression just given here that you just go and do your own thing. Obviously, you consult with your fellow ministers. We're working as a team. But I think it is extremely important for us to understand executive authority and when it is being usurped or when it is not being recognized.
I just wanted
Chair.
to, Mr. Mkwena, just wanted to emphasize that you are asking her about what the President may or may not do on the basis of her understanding of those opinions and not on the basis of anything else. Is that right?
Yes, Mr. Chair.
Okay, all right.
Mr. Chair, I'm
Because
told that it's quarter
I
past,
didn't-
it's quarter past
I
11.
didn't understand her to be a lawyer, and
No.
I don't know, she may be.
Okay.
Are you a lawyer, Ms. Hogan?
Am I?
Are you a lawyer?
No, I'm not.
Oh, okay. No, I just want to make sure that legal questions that are being put to
Yeah.
you, that you are asking, that you are answering them on the basis of your understanding
understanding.
of the opinions that you obtain.
Yes.
Yeah, thank
Exactly
you.
that, Mr. Chair.
Thank you.
Mr. Chair, I'm told that it's quarter past 11.
We shall take the short adjournment tea break, and we will resume at 11:30. We adjourn.